be a very sound document, a very strong democratic protection for the people against government.
These men differ over the most important single document in Texas, the Constitution of our state. The Constitution, the basic law of Texas, was born in controversy and is once again in controversy. The history and meaning of that conflict is our subject. We begin at one of the most historic sites in all of Texas, the hamlet of Washington on the Brazos. It is only a quiet countryside community now, far less dramatic than the famous Alamo or the battleground at San Jacinto. Yet, what happened here is in some ways more significant to Texans today than those famous battle sites. It was here, in this small frontier building, in 1836, that the Texas Declaration of Independence was signed, a necessary first step towards the formation of the Republic of Texas and later our own state of Texas. More important, it was here that while dictator Santa Anna's armies approached, the founders of the Republic of Texas hammered out a constitution. And why is a constitution, a paper document, so important? One way of defining it would be to say that a constitution is a collection of rules and principles by which a government is operated. Another, perhaps even better way to express it, is that the Constitution is the soul and conscience of a nation or state. The rules that determine how well, how safely, how happily a society of men and women live together. There are those who say the present Texas Constitution is hopelessly inadequate for this purpose. That is what we are going to look at, the past and the present constitutions of Texas, their good and bad points, and whether there is need for change. Texas constitutional government began with the Mexican Federal Constitution of 1824. It was adopted when Stephen F. Austin established the first Anglo-American colony in the territory. Farmers in Austin's colony contributed several hundred bushels of corn toward expenses of the Texas representative at that constitutional assembly. The key point in this document, where Texans were concerned, was that Texas and Coahuila were combined into a single state and authorized to prepare its own constitution. This document was drafted and published on March 11, 1827. It contained the first seeds of the Texas Revolt. Trial by jury and public schools, although promised by the Constitution, were never established. Dissatisfaction with this Constitution was widespread in the Texas colonies, but even then trouble might not have developed if the Mexican legislature had not passed strong anti-immigration laws. On April 1, 1833, the day that Antonio Lopez de Santa Anna became president of Mexico, Texas delegates met at San Felipe de Austin to petition for relief. They asked for repeal of the anti-immigration laws, organization of more adequate defenses against the Indians who were ravaging the border, and separate statehood. It was at this convention that newly arrived Sam Houston played his first big role in Texas history. He headed the committee that drew up a constitution for the proposed separate New Mexican state of Texas. Austin took the petitions and the proposed constitution to Mexico City, but his pleas were rejected and he was imprisoned. The following year, President Santa Anna declared that Mexico was not ready for democracy. He abolished the Mexican Constitution and became dictator. Other Mexican provinces became rebellious. It was under the approaching military shadow of the so-called Napoleon of the West, Santa Anna, that the most dramatic of Texas constitutional conventions was held. The Battle of the Alamo already was looming when the convention was called. It met at Washington on the Brazos on March 1st, 1836, during an icy blue norther. The meetings were held in this unfinished house, rented by local businessmen, who incidentally never paid the rent. The convention lasted 17 days, tense days, made even more so by the continuing bad news from the ill-fated Alamo. Several times, delegates, some with sons and brothers fighting at the Alamo, wanted to adjourn and go to the aid of the doomed fortress. Sam Houston kept the convention from disbanding. He argued that if the new nation was to survive, it had to be born with a legal status and the consent of the governed. Without it, there could be no help from the United States and no support from the citizens of Texas. On March 2nd, a Declaration of Independence, patterned closely after that of the United States, was adopted. On March 17th, the Constitution of the Republic of Texas was adopted. By that time, the Alamo had fallen, the defenders were dead, and the Army of Mexico was moving eastward. Most of the delegates scattered to recruit volunteers for Sam Houston's army and to fight for the government they had conceived. The following day, Washington on the Brazos was evacuated. It was not until September of 1836, well after Santa Anna's defeat at the Battle of San Jacinto, that the voters of Texas officially approved the Constitution of the Republic. However, the most popular of all the Texas constitutions was the one adopted in 1845, when Texas joined the Union. It was a pioneer document. It provided for homestead protection and women's rights. A family's homestead was exempt from forced sale, and a husband could not sell his home without the consent of his wife. It also recognized the concept of community property and the right of married women to own their own property. It instructed the legislature to set up public schools and set aside 10% of all tax revenue for education. Slave owners were granted permission to free their slaves. The next Constitution was adopted in 1861, after Texas seceded from the Union. Governor Sam Houston refused to call a special legislative session to consider secession. However, when citizen leaders called a special convention which adopted a secession ordinance, Houston was removed from office. The convention then drew up the Constitution of 1861. This Constitution was essentially the old 1845 document with amendments to fit changed circumstances. The preamble was altered to emphasize states' rights. Officials were required to take oaths supporting the Confederacy, and no slaves were to be freed by anyone. After the Confederacy was defeated, there was a period of turmoil and upheaval. A convention was called in 1866 to prepare a constitution which repudiated secession, slavery, and the Confederate war debt. This Constitution, however, was invalidated by the U.S. Congress. Edmund J. Davis was named governor. He was later elected by the voters. Another constitutional convention was called in 1868. This so-called carpetbagger constitution was adopted, the longest and most controversial in the state's history. It gave Governor Davis dictatorial powers, and he took advantage of it. He created a state police recruited largely from frontier desperados who used Gestapo-like tactics to break up political meetings and subdue the citizenry. It was this period of dictatorship that set the stage for the adoption of the present Constitution. R. Henderson Shuffler of the Institute of Texan Cultures is a student of this era.
In the fall of 1873, the majority of the people of Texas had an opportunity for the first time since the war to vote on what kind of state government they would have. They immediately threw out Governor Davis and his cohorts and replaced them with two very large, very strong men. One was Richard Coke, a 6'4" intellectual who weighed about 250 pounds and had the popular nickname of Old Brains. They replaced the Republican legislature with a new Democratic legislature. But Davis wouldn't accept the verdict of the election. However, the Democrats gathered in Austin in January of 1874 as though the court had not ruled. Davis stayed in control of the Capitol, and the whole thing was in such an uproar that as old Rip Ford, one of the toughest men in Texas who was appointed to help keep the peace during this disturbance, wrote several years later, if one shot had been fired, 20,000 people would have been killed immediately. However, Davis had appealed in the meantime to President U.S. Grant to send in federal troops to support him. Grant replied by telegram that he would have no part in the internal affairs of Texas. Within a few days' time, under great pressure, Governor Davis withdrew. The state was in such a horrible situation, so far as finances were concerned, that the entire operation was having to be financed with warrants which were issued for daily expenses and which were being hawked on the streets of Austin at 50 cents on the dollar. Koch and his friends set out to clean it up and straighten things out. One of the things that they knew would be necessary was a new constitution. So in 1875, at Koch's behest, a Constitutional Convention was called. One of the strongest points in this new Constitution was the opening Bill of Rights, which was set out specifically to protect the freedom of the individual Texan and to protect him from big and dictatorial government. The second important factor in the new Constitution was the limitation of the powers of the executive, with most of the power of government turned over to the legislature. The people of Texas had all of the dictatorial executive government that they wanted.
That is the key to understanding the present Constitution. The people of Texas in 1876 did not want any single government official to have any real authority. Their last governor had had virtual dictatorial powers. He was also empowered to appoint more than 8,000 state, county, and local officials, including all judges. The people responded by splitting up the executive branch into 7 different offices, but none have any real authority to take action. Few governments anywhere, national or state, have so weak a central authority as Texas.
Well, we need a complete reorganization of the executive branch. It's almost not too much to say we need the creation of an executive branch. We really don't have an executive branch under our present setup. The usual functions that one associates with an executive branch, education, welfare, regulation of industry, are handled by separately elected and appointed boards. But we need an executive branch along the federal model. We need our hundreds of state agencies reorganized into 14 or 15 topical departments of state government, each headed by a secretary, appointed by the governor, confirmed by the Senate. Only in that way will we ever have a truly responsive state government.
In a sense, we do have a cabinet form of government in the governor's office, because as governor, you have the authority to select the heads of the different divisions in the governor's office, such as your legal division, such as your Department of Community Affairs, and such as your comprehensive health programs. I suppose there's 6 or 8 heads within the governor's office. And then here's something else to think about. Under our present system, the governor has the authority, subject to confirmation of the Senate, of making all of the appointments to the boards, commissions, agencies, and authorities, such boards as the University of Texas Board of Regents, the Texas A&M University Board, and all of these different boards that have been created by the legislature. And when the legislature created these commissions, agencies, authorities, and boards, they were given certain authority under the legislature, by the legislature, to control whatever area that their commission pertained to. Well, in reality, these boards, these commissions, these agencies, these authorities, they are your state government. And these appointments are made by the governor.
But once those appointments are made and confirmed, then the governor no longer has any influence whatsoever with those appointees. The boards and agencies can do anything they please, and the governor's office has no authority over them, not even in a budgetary sense.
Many of the judges in the state of Texas feel that their jobs have been hampered by the extreme restrictions placed on them by the writers of the Constitution. For many years, the highest judicial authority in Texas was the Chief Justice of the state Supreme Court, Robert Calvert.
2 years ago, some of us undertook to make some reforms in the judiciary, and in nearly every instance we found we were confronted with a constitutional prohibition against those reforms. Our thought has been to completely revise the entire judiciary article, starting at the bottom or the top, whichever you wish. Starting at the bottom, for example, let us set up an administration of justice in all of the courts at a lower level, justice courts, municipal courts, county courts at law, so that these cases are brought to trial and disposed of. And district courts, let us do the same thing. And then let us speed up the appellate process to get them disposed of on appeal. We think revising the entire judicial section of the Constitution, and particularly to provide for central administration of the system, is the best way to speed up justice. Take you 2 years to get a trial of a jury case in some of the metropolitan cities of this state, and that's just much, much too long. That amounts to a denial of justice when you can't get speedy justice.
The writers of the present Constitution did not restrict the legislature as much as other branches of government. In fact, reacting against the dictatorial governor of Reconstruction days, they placed more authority than usual in the hands of the people's elected representatives. Yet even here, there are those who see a need for change.
In the legislative branch, we have a clear need for annual sessions. As a matter of fact, in the past few years, we've really come to budgeting on an annual basis, which is the only sound way to do it. It's costing us millions of dollars a year, really, to try to budget on a biannual basis. Annual sessions is the main thing that we need.
I have never favored annual sessions. Now, I would favor more authority, especially budgetary authority, for the governor. But I think the fact that the governor has the right to call a special session completely destroys any need whatever, or any basis of need for annual session.
Of course, the trouble with a special session is, if indeed it is a trouble, is that it can consider only matters that the governor submits. I think the legislature really ought to have more freedom than that, more time to do its business.
Despite the unusual dominance of the legislature in the Texas governmental system, it is still bound by specific constitutional limitations. So many do's and don'ts, in fact, that the legislature has had to submit more than 300 constitutional amendments to the voters since 1876.
Every time the legislature tries to start any kind of a new program to change the structure of the educational system or change the structure for building highways or anything else, we find that we run head-on into a constitutional provision. And we have to go back to the people with a host of amendments each time the legislature meets to try to change these constitutional provisions that really should have been statutory in the first place. Frankly, I think that it works very much against the public interest, because I think citizens, after a while, get very tired of having these issues submitted to them all the time, and they begin to wonder why the legislature can't legislate. And people don't stop to go into the historical aspect of why these amendments must be submitted. And of course they're all submitted in very legalistic language, and people are highly suspicious, particularly in these times, of anything that is not very clear to them when it's presented to them. So it really is a very awkward situation.
These limitations have also hampered Texas counties in the ability to serve their residents, according to Tom Bass, who was in state government before he became a county official.
We need to have more authority in the Constitution to conduct an urban county government and react more rapidly to problems that arise, I would hope that we would draft a constitution that would make the county fathers more responsible, so that if a problem is not solved, then we can say the Commissioner's Court failed to act. At the present time, the Commissioner's Court can say, yes, we failed to act, but the legislature did not give us the authority to, and the Constitution restricts us. If the Constitution gives the authority to the Commissioner's Court, then at least the voting citizens have someone that they can point the finger to. It may not solve the problem, but at least I think it pinpoints responsibility a little more.
Most Texans were farmers or ranchers when the present Constitution was adopted. Now a majority live in the cities. And the mayor of the state's largest city says the present Constitution does not fit their needs.
It's been my belief that the home rule principle should be extended to let cities actually have home rule. For example, the maximum tax rate is now set by state constitution. I think the people, the individual voters in each community, should be able by charter to set the maximum tax rates with which their local governments could operate. The designated areas where taxation is legal has been usurped by the state constitution, and it's my belief that the credit rating of the cities of Texas would be vastly improved if anything not specifically prohibited could be open for consideration by the people of every community for the levying of whatever tax is necessary to perform the functions that the people in that community feel is advisable and necessary.
But it's not just in the field of taxation that the present Constitution affects the people of Texas.
The inadequacies of the Constitution affect the citizens of this state adversely in a number of ways. First of all, it creates a very inefficient state government. We have scores and scores of different state agencies without any central direction. It makes state government an unwieldy sort of institution as well as an inefficient one with which a citizen has to deal.
Where they see the judicial process operate is at the trial court level. And at this level, they find the process slowed down to the point where they sit for hours waiting to be called for jury service, and then maybe are excused and they've lost a day from their business or from their work. Or they see a sloppy process of trial and disposition of cases. And I would say that the process is not very conducive to public respect for the judiciary.
Well, it affects all the people, because actually the legislature, the members of the legislature who represent the people when the legislature's in session, they are guided and controlled by the provisions of the Constitution, which in turn makes the Constitution really the controlling factor over the lives of all the people through the actions of the legislators.
There have been numerous attempts at revising the Constitution, beginning as far back as 1917 and continuing until today.
So this time, the authors have tried a new approach. They're using a commission of private citizens, or actually it will be a commission of people who are very, very well-versed and knowledgeable in government and governmental operations and constitutional law. And from this private citizen group of people who really know what they're doing, we feel that we will get very good recommendations and very good rewriting work done. That then will be submitted to the legislature. The legislature will go into session if the people approve the November proposition in January of 1974, and will act on those recommendations from this commission of experts or people who are very knowledgeable in the field. It's far superior to trying to have the legislature, which is a part-time body, try to do the job themselves.
The proposition for revising the Constitution will be on the November 7th ballot in the general election as Amendment Number 4.
Under the terms of the amendment on the ballot, the convention, which hopefully will sit in 1974, will draft an entirely new Constitution. It is not compelled to do so It can offer amendments to the existing articles, can offer a series of amendments. It can do really anything it wants to in that respect. The only prohibition in the amendment, the only inhibition, I should say, being the restriction that the Bill of Rights should be retained unchanged, which certainly nobody would wish to tamper with anyway.
There are serious doubts in the mind of some about the amendment for constitutional reform. These center around the questions of whether the legislature is the body to do it. Attorney Cooper Reagan is one who raises these issues.
I'm not the one to say that there shouldn't be any changes, but I think we ought to do it piecemeal, so to speak, by revising instead of adopting a new instrument. I feel that there should be a constitutional convention, and I feel that the delegates of that convention should either be selected by a board consisting of perhaps our highest elective officers of the state government, or perhaps by a vote of the people of each county, or by the vote of the people of each senatorial district or each congressional district. I don't think the legislature, by and large, or the legislators themselves are qualified to rewrite the Constitution.
On November 7th, you will be asked to decide if the Texas Constitution should be changed. It is the first time in 53 years that Texas voters have had that choice. Your decision may not be made under the same dramatic circumstances as those facing the citizens here at Washington on the Brazos in 1836, but the decision is the same. This time, you must choose the kind of government you want. This time, the decision is yours.